As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Islam Moors.
My nationality is Moorish.
These men are part of an anti-government group called Rise of the Moors. Our chief investigative reporter, Cheryl Fiandaca, joins us now. And Cheryl, this is a group that does not believe it needs to follow the law.
That's right, Lisa. Members of the Rise of the Moors say they're independent of the government. They believe Rhode Island is their sovereign territory, and any abandoned buildings can be claimed for the Moorish people. The group is also very interested in weapons.
We have 3 guns.
Bragging about his arsenal on his YouTube channel, Jamal Latimer, also known as Jamal Talib Abdullah Bey, the self-proclaimed leader of the Rise of the Moors, suggested he would shoot an FBI agent.
The FBI tries to do an illegal search.
Or neutralize you?
Yeah, or neutralize me while I'm at home. We got slugs.
Many months later.
Hear ye, hear ye, hear ye. All persons have anything to do for the Honorable Judge Deacon, Justice of the Superior Court, now sitting Woburn, for the transaction of criminal business. Draw near, attention, it shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. May be seated.
Jurors, welcome back. Has everybody been able to comply with the instructions I need for reminding you at trial day yesterday? All jurors indicating affirmative by saying so, and we're nodding their heads. We can proceed. Commonwealth, next witness. Yes, the Commonwealth called Mark Delaney.
Next, the clerk is going to be.
Please solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Morning, Trooper Doctor. Yes, good morning. Welcome. You may proceed, counsel. Thank you, Your Honor.
Sir, good morning. Good morning. Nice clear voice so that everybody can hear you. Please give us your name. Would you spell your last name for our report, please?
Mark Delaney, Delaney.
What do you do for a living, sir?
I'm a trooper with the Massachusetts State Police.
How long have you been with the Mass State Police?
A little over 10 years.
What is your current assignment?
I'm assigned to the State Police Detective Unit for Middlesex County in the homicide unit.
Okay. What are your duties and responsibilities then?
We investigate all unattended and suspicious deaths within Middlesex County, include homicides, suicides, overdoses, medical deaths outside of medical facility, anything that we just deem suspicious.
In that role, you also participate in other investigations being conducted by the district attorney's office that are not related to this.
I do.
And before you came to the Middlesex State Police Detective Unit, what assignments did you have with the State Police?
I was a trooper assigned to the State Police Andover Barracks, also a road trooper, 93 and 45 in the Andover Mobile Arms area.
So that's a uniform control position?
Yes.
And were you working as a trooper on July 3rd, 2021?
I was.
Did you respond somewhere that morning?
I did.
Approximately where did you respond?
I responded to 95 northbound in Wakefield.
Okay. About when was that?
6:30 in the morning.
Was there a particular area that you went to?
I went to the college command post that they had set up. It's a large, it's a large box company used for safety issues for their command post for large incidents.
And a little bit later that morning, you respond somewhere else, part of that investigation.
I did. The next place I went to the Lake Clinic in Rome.
Okay. Was there a person you observed at Lake Clinic in Rome?
Yes.
Who was that?
I was terrible with the name, but I forget his exact name. I had to refresh my memory.
We'll come back to that.
Did you, following that, was there someplace else?
I went to the vendor that accepted that.
Later that day, you ended up going to, what's called A6 or the damage barracks.
I did.
And was there a particular location within the barracks?
I went to the garage.
And what, if anything, did you observe in the garage?
The transit van and the gray Honda pickup truck of the Honda Ridgeline that then will move to, they're inside the garage of A6.
And did you remain there for a period of time?
I did.
About how long were you with the damage van?
Probably 2 to 3 hours.
Did there come a time, at some point that evening, when other troopers also came to the garage with the two vehicles being sorted?
Yes.
And was there a point at which vehicles were examined and things removed from them?
Yes.
Who was doing the searching and removal of these items?
At that time, it was mostly ballistics and crime scene services.
And what role did crime scene services play in this searching and removal of items from the van?
Documentation of the activity that was going on. They were doing photographs.
And generally speaking, what sorts of items were being removed from the van that they got from?
Firearms and ammunition.
Did there come a time where you yourself had a look at the gray Honda Ridgeline, silver Honda Ridgeline?
Yes.
Okay. And was there a particular item that drew your attention in the rear seat area?
Yes.
What was that item?
A cell phone.
Do you remember, can you describe the phone in a little bit of detail?
There was a black iPhone, a black case, and it had a cracked screen.
So you said 81 already in evidence. Could you tell me, you recognize exhibit 81 and the things that take on?
I do.
What is it?
This is the rear passenger seat just behind the driver's side seat of the gray Honda Ridgeline. And on the floor, sort of against the wall of the vehicle is the cell phone next to some firearms.
I will put this on the projector, and I would ask you, with the court permission, if you could just point out on the TV screen the phone you just described.
Okay. If you want to step off the witness stand and point on the screen, feel free to do that.
The cell phone I was describing is right here, leaning up against the forward wall.
Thank you. What did you do with that cell phone once you located it in the vehicle?
Secured it as evidence and transported it back to the Middlesex District Attorney's office.
How did you do that? How did you secure it?
Placed it in evidence bag. Basically, for the airplane mode, and then transported.
What is the significance of putting it in your plane?
Just to further prevent any manipulation of the device from an outside source. So, for example, you can, especially by iPhones, you can wipe your iPhone, you can remove things from it. So, remotely from a computer or an iPad. So, it just, I think the device for the airplane mode so we can't connect to any networks. It also just preserves the evidence as it is any further anyway.
They hand you an object.
look at that bag, look at the markings on the bag, and also look at the item in the bag if you're able. Tell me if you recognize what that object is.
I do.
What is it?
This is the black bag for that, with the recovery of the Harvard Bridge Market. That is one that.
Apart from being in the silver bag that you're holding, is it apart from that, same condition or substantially the same condition today as it was? You probably
Yes.
offer this to the next exhibit.
No objection.
No objection.
Without objection to the exhibit, I think it's 125.
125.
I'll just display that for the jurors. After recovering the vehicle, after the ballistics, he recovered various items from the vehicles. What was done with the vehicles?
They were eventually towed to dispose for you.
Was there a point later on in the summer where officers went back and examined the remaining property in those vehicles and photographed it?
Yes.
Turning back to the cell phone, have you received any training in your role as a trooper pertaining to examining cell phones and recovering data from them? Could you tell us a little bit about that training?
Sure. So majority of my trainings come from a company called Celebrate, which is one of the main software we use to do extraction of devices. So I have the CCO, which is the Celebrate Certified Operator, CCPA, which is Celebrate Certified Physical Analyst. I've also completed called the CASA certification, which is the Celebrate Advanced Smartphone Analysis certification. I've also have experience with a company called now Axiom with Great Key software, as well as ADF mobile device software as well.
Okay, let's start with Celebrate. So Celebrate, you described as a software that you use. In your role as a trooper, and with respect to examining cell phones, do you know whether or not Celebrate is used widely within the field?
Yes, it is.
What does it actually do?
One thing is it has the ability to bypass security passcodes in one of two ways, either we call it brute force, which is where it actually identifies the passcode of the cell phone, or it just bypasses the security mechanisms and pulls out the files from the phone. Depending upon the make and model of the phone, the iOS, it depends upon the software decides what's the best method to use. Great Key operates the same way, but if we're focusing on Celebrate, those are two ways of basically extracting the data from the device.
Okay, so have you been trained on how to do extraction of phone data using these software?
Yes.
And generally speaking, what is the methodology you follow when you do these extractions?
It's really just using software. So the software attaches to the phone through the USB port. And the software kind of takes you through a step-by-step process, analyzing the device, and the software really makes the decision of what the best method is to extract that device and to extract that data. At the end of it, it either tells you it's able to be extracted or not, and it tells you sort of the level of the extraction. So typically what we call a full file system extraction, but sometimes it might be a partial file system or logical extraction, which is kind of less and less data. I always use the example of a file cabinet. So a full file system would be kind of every file, or the vast majority of every file from the file cabinet, and then a partial or logical would be sort of less and less files. So 4 doors that are locked that we can't get into, and you just can pull out less data. Once we pull that data, sort of the magic of the software is embedded, organizing these files, this data, databases, into something that law enforcement can search and find artifacts of evidence for whatever investigation may be. And then we can integrate that to different files that other investigators who don't have the training I have can still use to then search the device and try to find things that are important in their investigation.
Okay. And in your career with the state police, how many different times have you used the software tools to extract data from cell phones?
Over 200. So somewhere between 200 and 300.
Have you ever had to testify in court about data you extracted in your examination of the data after?
I have.
In what courts?
I've been in Superior Court or Old Superior Court.
Okay, so here up in Lowell.
Yes.
When the data is extracted, is there anything done by the software or the examiner being used to verify that it came from the device? And can you go back from an extraction, verify that things the software has put into the extraction are actually on?
Yes, so every time you look at any, whether it be a photo or a message or a phone call, there's always going to be a called source file that Cellbrite will provide. That source file shows you the database where Cellbrite pulled that data from. And through Cellbrite, we can then go into the original data file to just verify that that information, whether it be a phone call or a text message or whatever, is actually there.
And so the data that Cellbrite will extract off the cell phone, if I understand your testimony, there's different types of I guess what users would recognize as content, meaning messages, call logs, things like that.
Yes.
Okay. The Cellbrite software separate those out of the databases that you then described or can be examined by investigators later on.
Yes, the databases really are separated out by Apple or Android or whatever the phone manufacturer is. Cellbrite then organizes that. We can look at the sense of it. It organizes it somewhat differently, but than what's in the original data files. But generally, it puts it into a system that most people are more familiar with. When they look at their cell phones, it's going to be call logs, MMS messages, SMS messages, photographs, movies, videos, location data, and then it gets into things that you can't see on our devices, which would be showing the database that shows when you open and unlock your phone and use your flashlight and all those other things as well.
So the things that the device keeps track of that maybe the user's not aware of, the device keeps track.
Yes.
So once you got the cell phone back to your office at the State Police Detective Unit, did you then do something with Cellbrite with respect to that black cell phone?
Yes, actually, I used Reiki software to do the extraction of the file system.
Okay. Once so does Reiki, how does Reiki operate compared to your description of the Cellbrite software so far?
It operates the same way. It's a different company that tends to be more inclined to for Apple devices.
Okay. So Reiki's focused more on
yes. It's changing one time, but historically, yes.
Okay. So what did you do with the Reiki software with respect to that black iPhone that I showed you before?
So I utilized Reiki and extracted a full file system extraction of the device.
Okay. And is that, I understand your earlier testimony, is that sort of the optimal type of extraction you can get on a cell phone?
Yes.
Okay. And then, is there something that, is there a tool you then use to then sort and examine that extracted data?
Yes.
What was that software?
So that's going back to the Cellbrite software, the physical analyzer software. So then the Reiki basically creates a zip file of all the files that are meaningless to just look at, just data. We then load that file into Cellbrite Physical Analyzer, and then Physical Analyzer, so the Cellbrite then parses out that data, it puts it into that organizational structure that I can then look at and review.
You can look at it.
Yes.
And so, Is there something that Salvary can generate called a preliminary device?
Yes.
And what is a preliminary device report?
So it's just going to be usually a 1 to 1.5 page report. That's just going to show all the basic data of the phone. So it's going to provide the make and model of the device, the IMEI, the MC, which is ISI. It's going to give you if there's any a name associated with the device, what's the name of the phone, something, or if there's an iCloud account attached to it, or a email system attached to it. So there's a lot of data about the device.
And you used a bunch of acronyms a minute ago, IMEI, MC, and some other things. Would you please tell the jury what those things are?
Sure. So the IMEI is the International Mobile Equipment Identifier. So that's going to be the number associated to that piece of machinery of your phone. The MC is the subscriber identity, which is going to be tied to the SIM card of the device, and then your trying to mention as part of that, well, they come up later on is MSIDN number.
Yeah, if you wanted to put another question to
Sure. So, if there, you told us about the IMEI, you told us about the MC or IMSI, and you a moment ago told us other information in the preliminary device report. Are there fields in there that will correspond to phone numbers?
Yes.
And so what are the technical references to the things in the preliminary device report that ultimately correspond to phone numbers?
So one of the things is on there will be system another name for a phone number, the MSISDN number. And that's just going to be the phone number that we all know, the phone number of phones that's tied to the SIM card of that device.
And all this information can be put into the preliminary device report for a particular device.
It's done automatically. It's not something that I don't have control of what goes in and out of that. It's just something that does that on its own.
Let me show you a second object. Let me show you. Was there a second device that you also examined as part of your investigation?
Yes.
Let me show you exhibit 68, which is in evidence. Tell us if you recognize. Exhibit 68, please look at the markings on the bag as well as the contents of the bag. The extent. So,
yes.
What is exhibit 68?
This is the iPhone 8. Black iPhone.
Okay. The bag indicates it was recovered by Lieutenant O'Rourke.
Yes.
Okay. What, if anything, did you do with this device once you located it at the Safety Inspector Unit office?
The same thing that I did with the other device, which was to use Grade to conduct a file system extraction.
And was a preliminary device report generated for that one as well?
Yes.
Did it contain the type of information you explained to the jury in a few minutes?
Yes.
Let's show you. Show you exhibit 125 again, in this one-page document. Tell us what the document is first. Get it identified.
This would be the preliminary device report.
Okay. And how does it relate, if at all, to the object, the phone, which is exhibit 125?
This is the preliminary device report for this device.
That device report contained the identifiers you were telling the jury about that Celebrate extracted from that device.
Yes.
I would offer this as 125A.
Without objection, then it would be exhibit 1.5A.
Exhibit 125A on the projector. Do you see it's titled Celebrate Preliminary Device Report, Apple iOS Full File System? Do you see that? Got it. Why don't you?
All the jurors see that on one screen or the other? I was afraid it would be a bit of an eye test.
Yeah.
Do this.
Trooper, if it's easier for you, if you could stand by the television screen and you could, with the court's permission. All right. Do you see the field phone settings? See that in bold at the top?
Yes.
Okay. And there's an Apple ID listed in the phone settings. Do you know what an Apple ID is?
Yes, it's your.
Keep your voice up.
Yeah, it's the your Apple subscription, your personal Apple ID number for your Apple.
Okay. Do you see where the value set for the Apple ID is something called jamalsflicks@gmail.com? See that?
Yes.
Okay. And below, do you see a field last used MSISDN? See that phone number for that field?
Yes.
And to the right, do you see a value set for that field?
I do.
You just read into the record what that says.
1-401-428-3411.
Okay. And do I understand your testimony that the MSISDN essentially corresponds to what you and I would call a phone number?
Yes.
Okay. The area code 401, do you recognize what state uses 401?
Yes.
What state is that?
Rhode Island.
Okay. Down below, there's a second field that says just MSISDN. You see that?
Yes.
And do you see that it's the same number you just read to the jurors?
Yes.
You can have a seat. Using this extraction, you've also, with a report generated of certain files that you located on that phone.
Yes.
And can you describe generally what types of files we're talking about that you generated a report for?
They were videos.
Okay. And do you recall anything about the way those videos were filmed? Meaning, were some of them filmed just traditional filming style, or some of them filmed in the sort of selfie format?
I definitely remember some of them in the selfie format. I believe there were also some in the other format as well.
Okay. And was there anybody of interest that you could observe in any of these videos?
Yes.
Who was that?
There's multiple individuals in the videos.
And from your review, were those individuals, they appear to be related to your investigation?
Yes.
How so?
They were all of the individuals that were on I-95 in Wakefield.
Right, have you seen it sidebar? It may make sense to do it as a real sidebar. And does it list the date and time of creation in the metadata as well?
It does.
And how does that line up with the information elsewhere in the report about when the reporting was made?
Looks like the creation date in the metadata. matches the creation date for the file.
Okay. Now there are, in the far right column, there are little color pictures. You see that?
Yes.
What are those?
Thumbnails.
Okay. What is a thumbnail?
It's just a small, typically small image file that is created by the device just to reference, has reference connection to the original movie file.
So it's not something that you drew and put in the report yourself?
No.
So what creates it?
Your device creates it. Typically, when you look at images from a device, you're going to see images in the original files, but you also see what we call thumbnail files, which are very small, usually 1 byte files that just give a display of what that image references.
The Commonwealth offers this as 125 B is the point.
Objection, what was discussed at that point?
This is what's being
So the extraction.
regarding your proposed redaction issues that.
Right.
All right, that objection is overruled. It can be more considered one.
I'm going to show the jurors. And Trooper, you may want to stand by the television, just so we can walk the jurors through the different types of things you talked about. Okay, so do you see that I placed the extraction report on the projector on the TV? I'm going to move it down a little bit. All right, there's also some information. You see that it's got a name and it says IMG 4016.MOB. What is that?
That's the file name associated to that file.
Okay. What's the information directly below it that is to the right of the word path?
That's the source file, so that's telling us where on the device the data came from. So most once if you plug in your iPhone, you'll see the DCIM folder, which is the DCIM folder is always a folder, the data that's typically in the original photo file of your movie file of your device. And then this is basically it's a folder structure. The DCIM 104 Apple, and then that's where this movie file is for the 104 Apple folder under the DCIM database.
Okay. Now there's a field below path that says MD5. You know what MD5 is?
I'm not that familiar with it, but it's sort of a hash. It's a way to verify.
And so there's some information to the right of the MD5. Is that so that ultimately one examiner can take the extraction, go back and verify it against the device?
Yes.
Now there's information to the right. I'm going to slide the document over a little bit. There's additional file info at the top, and we have a field is a size parenthesis bytes. Do you see that?
Yes.
What's that?
That's just the size of the file. How big it is.
Okay. Now there's 3 fields below that: created, modified, access. Do you see that?
Yes.
And set to the right appears to be the same information for all 3 fields, but it's July 2nd, 2021, 11:24, 34 seconds PM. Do you see that?
Yes.
And it indicates that's UTC-4.
That's correct.
What does that correspond to?
UTC-4 is the local time zone, so UTC actually stands for Coordinated Universal Time. You know, it's UTC and UTC. But Coordinated Universal Time in Boston, we are -5, so it's -5 hours from the old Greenwich time that we're familiar with. And then UTC -4 is when we go to daylight savings, summer time in New England, we switch to -4. Make up for that. So as an examiner, cell phones and most computers keep everything in UTC-0 in their times, the databases. So Cellbrite translates those times to be, so we can calculate what it's happened in our time zone. So as an examiner, I always want to make sure that that UTC-4 is there. Then I know that it's been auto-corrected for the correct time. Because sometimes you might get a report that could be UTC-0. You should have to know that could be 4 to 5 hours off depending upon the time.
Now, why are there 3 fields for created, modified, and access time? Can you explain those entries?
Sure. So if it was basically if the file was modified or accessed a second time, that would be a timestamp associated to that. So what this is showing is that the it was created and not modified or edited within the device.
Okay. And then we have something down below called source file with this long string of text. Do you see that?
Yes.
What is that?
That's something we're talking before, so it's going to show that same file path, which is GCIM, 104 Apple, and then the name of the file.
Down below, do you see the field underlined as metadata?
Yes.
Okay. And this tells us it was, the file was recorded by an Apple iPhone XS. Do you see that?
Yes.
And it also lists a creation date, which corresponds to the information above. See that?
Yes.
To the right, what am I pointing at?
That would be the thumbnail file.
Okay. Now, lastly, there's a column over here on the right that says deleted. There's nothing in there. What is that? What's the significance or what is the meaning of that?
If this was a file that had been deleted, it was recovered from a deleted database, it would just say, it would say yes right there.
Okay. You can have a seat, sir. Before we get to the actual file itself, let me ask you about the second device as well. I'm going to hand you the device one more time. What exhibit have I just handed you, sir?
This is a iPhone.
iPhone 8?
Yes.
Have an exhibit number on it.
Exhibit 68.
And that you, it's one-page document. If you look at that one-page document, tell me what that is, and then how it relates to exhibit 68, if at all.
Yes, this is the device report, preliminary device report for this device.
Okay. And is that the same type of report talked about a few minutes ago for the other phone?
Yes.
Does it have the information about the phone that is exhibit 68?
It does.
Okay. And take that back. I would offer this as the next. So, excuse me, 68A. It's not. No objection.
No objection.
Without objection, that preliminary device report will be marked exhibit 68A.
You're going to have to stand by the screen again, Trooper. I'm going to put exhibit 68A on the projector. You going to put the device report up there?
Yes.
Can you see the Apple ID field for this particular preliminary device report?
Yes.
You tell the jury the email address or the account name that's specified for the Apple ID field?
Yes, it's Latimer417@gmail.com.
Okay. I'm going to put just for a moment exhibit 15 on the projector. You going to put exhibit 15 on the projector?
Yes.
So it's got a picture to the left. Does it have a date of birth listed in this Rhode Island DMV record for Jamal Lattin?
It does.
What's the birth date? What's the month and day, I should say?
4/17.
I see. All right, coming back to exhibit 68A. Do you see a MS-ISDN number attributed to this device in the preliminary device report?
I do.
Can you tell the jury what the phone number is?
401-403-5176.
Okay. And do you see that same number in an earlier field for the last used MS-ISDN?
I did.
I'm going to put page 4, exhibit 15 on the projector. You see that this report, this is a state of Rhode Island, essentially a DMV handwritten application for someone named Paul Latimer. Do you see that?
Yes.
You see the date of birth listed as 4/17/1992.
I did.
You also see a telephone number listed.
I did.
How does that phone number relate or differ to the one to the MS-ISDN for that phone you examined?
It's the same number.
And again, you testified earlier, 401 is a Rhode Island area code.
Yes.
You can have a seat, Trooper. You also bring with you today a thumb drive. I did. Handing you an object. You would tell me it's thumb drive what this object is.
This is the thumb drive containing the digital files for the reports.
And these come from the extractions you've been testifying about?
Yes.
I'm going to show you this multi-page document. I believe it's several pages. You just look through that, tell us what that is. These are
images from a Telegram chat, which from Telegram path, file path.
Okay. And does that correspond to the second telephone you've been testifying about?
Yes.
And this, what is this document titled?
Extraction report.
Okay. And it's got not every file on the phone, but it's got some files. That'd be accurate.
Yes.
And does it contain the same fields and types of data that you gave examples of using the other extraction report that we have already in evidence?
Yes.
Does it also have the same thumbnails off to the right corresponding to each image or video file in that extraction report?
It does.
And as before, are those generated by the computer or by you?
The thumbnail is generated from the device. That just comes out of extraction.
Okay. And the types of files, describe them as being part of a Telegram chat, but what types of files are they? Meaning, are they text documents? Are they spreadsheets? Are they audio recordings? Images? What?
These are all image files. Say what kind of files they are.
In the report, the thumbnails are present. And in the electronic version of that, is it applicable so you can get to a larger version of that?
Yes.
What are the things I've just handed you now?
These are the larger images from the thumbnails.
You click the thumbnail and you get to that larger image?
Yes.
And did you review them before coming here today?
Yeah, I haven't seen it in a while, but yes.
You're familiar?
Yes.
Are they potentially duplicates of what the thumbnail brings up when you click it on your personal computer?
Yes.
Be sure. Having shown these to council, Your Honor, the Commonwealth offers the extraction report as I think 68B is in boy, corresponding to the exhibit number of the phone.
Objection is to the extraction report by the same grounds are raised for exhibit 125B at the sidebar earlier.
For the same grounds, the objection, so believe it would be exhibit 68B.
And the photographs, the witnesses identified as being the larger versions of the thumbnails in exhibit 68B, I would staple and offer collectively as 68C as a chart.
No objection.
That objection would be exhibit 68C.
The thumb drive containing electronic versions of the items in 68B as well as documents from the other phone as well. I would offer as 68D as a bid.
Where it contains items from two separate exhibits, I think well, subject to any objections, I would remember the next sequential exhibit, but
I didn't have an objection. I just had the same comment about the two separate reports being on the same flash drive.
I think it's not reports, I think it's actually files.
Right, that's what I meant.
But yeah, so without objection, or Mr. Resident, do you object? No. It would be exhibit 126.
Thank you.
I mean, just the prior objections.
Understood, yeah, I mean, new objection.
Okay. You could, we'll do it this way. I'm just going to publish exhibit 68B quickly. Trooper, you may want to stand next to the screen if it's helpful. You see I put exhibit 68B. You see the thumbnail over here that I'm pointing to?
Yes.
Okay. And you see that according to this is taken July 3rd, 2021 at 8:27 a.m. See that?
That's correct, yes.
Okay. You see the photograph I put up from Exhibit 68C on the first page?
Yes.
Then at the bottom of 68B, first page, there's another thumbnail. You see that was created July 3rd, 2021, 8:27 a.m.
Yes.
You see that I put up the second page, 68C is in Charlie.
Yes.
And the report, 68B, has the creation time for many of these files. Varying times on the morning of July 3rd.
Yes.
There's one file we'll get to, which is created on July 2nd, 2021, 2:03 p.m. See that?
Yes.
And what do you see that appears to be a black item with yellow in the middle?
Yes.
So we'll go through the rest of the photos. Just so the jury can see them. This is page 3 of Exhibit 68C. Page 4. Right. Page 5.
Yes.
Page 6.
Yes.
Page 7.
Yes.
Now, we talked a moment ago about a photograph with black and yellow, putting up Exhibit 68. The next page of Exhibit 68C. Do you see that?
Yes.
Is that the enlarged version of the thumbnail?
Yes.
See that the black item that appears to be a bag?
Yes.
These images that I'm showing at this point are all what are taken in the so-called selfie format, meaning the camera appears to be turned around.
Here we go.
You can resume your seat. We're going to put Exhibit 126 into on the screen. All right. But publishing file IMG 4016.mov from this exhibit. Using Exhibit 125B, Trooper, can you give us the date, time this was recorded?
This is recorded July 2nd, 2021 at 11:24 and 34 seconds p.m.
For the record should reflect this is an 11-second video. Maybe turn the volume up. I'm just gonna play that one more time, a bit slower. It's only 11 seconds. I'm gonna play it at half speed. I'm playing the next video. Can you, using the report, can you tell us the file name and the approximate date and time it's recorded?
This is image file 4017.
Yes.
This was created July 2nd, 2021 at 11:25:04 p.m.
We cannot, we'll be on the outside reception. We'll be on that.
I'm gonna play that again at half speed because it's so short.
Nine will be on the outside reception. We'll be on that.
Third file is what, and what's the date and time of creation?
Third file should be image 4018 movie file created July 2nd, 2021 at 11:36 p.m. 33 seconds.
Okay.
Yes. Oh. Yeah, I mean, you're all set. So that stay hopefully.
Okay.
For what's the next video?
The IMG 4019 John FOV movie file created July 2nd, 2021 at 11:32 seconds p.m.
I'm gonna restart that at half speed. Yeah, I'm just gonna direct your attention to one moment of this. See that I've paused it at about 6 seconds into the recording. You can see that?
Yes.
You see the individual standing on the screen?
Yes.
You see that there's a dark colored object between that individual's right arm and his body here? Yes. Gonna go back to one video and you just stay there. I've opened up the second video, you see that there's an individual standing in the back, apparently over the left shoulder of the person in the foreground.
Yes.
Do you see that? You still see that individual at 4 seconds into the video over the right shoulder of the person in the foreground.
Yes.
You can resume your seat, Trooper. Moving on to, there's a file IMG_4020. You can tell us the date and time that was created.
July 2nd, 2021 at 11:53 and 20 seconds p.m.
Play that one again at half speed. Second to last video, IMG_4020. You see that?
40, 40.
Excuse me, 4021.
It's created July 3rd, 2021 at 12:00 and 51 seconds, just after 50 seconds after midnight. Okay.
Attention. All right, let's go. It's midnight. Here, let's go. Let's go. Here, this way. Here. Here, come.
Playing that at half speed.
Pay attention. All right, let's go. It's midnight. Here, let's go. Let's go. Here, this way. Bear. Bear, come.
Now, you mentioned the Telegram chat earlier in your testimony. Do you recall that?
Yes.
And what is Telegram?
It's a messaging communication application.
And can it be installed on a person's cell phone?
Yes.
And with Telegram, can you have chats that involve not just two people, but larger groups?
Yes.
Now, was there a particular Telegram chat you took note of on the second iPhone?
Yes, it was.
When you brought that chat up in the searchable Celebrite software, did it have a particular name for that chat?
It did.
You recall the name of it?
Don't recall the exact name of it. I know it's something along the lines of, Moorish committee or something like that. It's 3 words.
Okay. And was a report generated from that Telegram chat?
Yes.
Tell me what I just handed to you.
This is a summary extraction report of that Telegram chat.
And so have you gone back to well, let me ask you the various messages it extracts from the chat, what's in the report. There's also source information for all those messages, is there not?
There is.
And are the contents of this report from that chat found on the extraction from the second iPhone?
Yes.
And the report is generated by the software itself, correct?
That's correct.
Does that include any messages in the Telegram chat that have emojis or thumbnails?
Yes.
I would offer this as, I think this should be maybe 68. E is in, goes with exhibit 68. I think we're up to either D or E. D.
Objection.
And objection.
Previous objections already addressed or new objection?
Previous, but I would like to be heard.
Okay. Exhibit 68.
When a person installs Telegram on their device, does Telegram give them an account number, unique Telegram that's distinct from their cell phone number?
I am not familiar with that.
Actually, you see on the front page of 68D what I'm pointing at?
Yes.
Mall of Bella Bay.
Yes.
And you see that it's unlike all the other persons before and after, this one is listed as owner.
Correct.
Okay. Looking at, well, I have copies for the jury to judge the report. Follow along that way. That would be easy.
If the could ask the court officer to distribute copies to the jury, and while the court officer is doing that, if I could be just speak to the parties very briefly over the headset. Madam Court Officer, Mr. Court Officer, if someone could distribute these to the jury. Jurors, just so you understand, these are copies. The exhibit itself is the evidence that you will have with you in the jury room. The copies are distributed to you to help you follow along, rather than try to squint at the screen and read small text. I can speak to the parties. If I could have a copy as well.
This one.
Or maybe enough for Mr. Matos and Ms. Noble as well.
Judge, to
Yes, to the defense. Yeah, so yeah, that's fine.
Okay. I'll take the exhibit from the witness. Without if we don't. All right. So, first thing I'd like to do is put up page 3 of exhibit 60B is being on the projector. I'm going to do that because although we have copies for everybody, the print is a little small. So that way, if anybody's having trouble reading, they can follow along on the screen. You see that there's a message. The bottom of the message, you see that it's June 6, 2021, 4:07 p.m. Do you see that?
Yes.
You see that there's a post from somebody named Jamal Abdullah Bey, owner,
Yes.
for something called Operation Fountainhead. Do you see that?
Yes.
Okay. It's titled what after the date? In the first line.
Operation Fountainhead, July 3rd to 7th, 2021.
Something called packing list?
Yes, fabulous.
Okay. Among the items, you see where it has it lists firearm, ammunition. You see that?
Yes.
And before I move the thing over so we can see on the screen, it also calls for a rifle cleaning kit and something called a plate carrier with level 3 SAPIs. SAPIS. You see that?
Yes.
See, it also calls for two-way radios a little bit further down.
Yes.
To the right of in the first line where it calls for ammunition, you see where it calls for 4 30-round magazines?
Yes.
All right, so following this, and it has a bunch of other materials to be collected. Do you see that as well?
I do.
All right, so now then there's a response from somebody named Connell Pierre. Do you see that what are those colored things below the name Connell Pierre and above the date 6/6/2021?
Emojis.
All right. There's a thumbnail on the second page in the top left from somebody named Connell Pierre. Do you see that?
I do.
Okay. And can you describe did you ever watch the video connected to this thumbnail?
I have.
Okay. And can you just summarize what one would see if one were to click that link and follow it to the video?
It's a video of an individual dressed in scrubs, because he's a doctor or some sort of medical professional, giving instruction on how to try to get a first aid to a bullet wound.
In the videos, there are reference to what to do if you're in the back country and calling for help on a satellite phone.
Yes.
Going back to the exhibit, a little further down, do we see a second message from Connell Pierre, 6/6/21, 4:32 p.m. BTW, does anyone have a sat phone asking for more? Do you see that?
I do.
And what does sat phone appear to be a reference to?
I believe it's a satellite phone.
Let's move ahead. Page 6 at the top left. Did you get a message from somebody named Quinn?
Yes.
On June 11th, 2021, just after 12:04 p.m.
Yes.
A little further down, we have a message from somebody named Therese Bay on the same day. You see that?
Yes.
And then we later on have a message from Jamal Abdullah Bey, owner, talking about the Marine Corps Rifle Squad. You see that?
Yes.
All right. Top of page 7. You see that we have a message from that same individual, Jamal Abdullah Bey, owner. 2 major techniques of squad assault are bounded fire and advancing under the cover of suppressive fire by supporting units. You see that?
I do.
Okay. And then it talks about what bounding fire is. Talks about various field maneuvers. Do you see that?
I do.
Okay. A Below that, you see a second message from that same user at 9:55 a.m. and 20 seconds.
Yes.
In military operations, reconnaissance or scouting is the exploration of an area by military forces to obtain information about enemy forces, terrain, and other activities. You see that?
Yes.
All right. On page 8, you see we have two posts from Mall of Dollar Bay owner. And I'm not going to ask you to read the whole text into the record, but what do these appear to be?
Talk about the 5-paragraph order, which I understand to be the way to give out military orders.
And then there's further numbered lists of things talking about, for example, subordinate units, enemy courses of action, things like that. You see that?
Yes.
Top of page 9, you see we have a explanation by somebody named Jamal Abdullah Bay about what a military unit known as a company, how many soldiers comprise it.
Yes.
Oh, do you see the response from both Quinn and then a little bit later, Sharif Bay at the bottom of page 9?
Yes.
Top of page 10, you see a statement by, partial statement by Jamal Abdullah Bay, owner. This could be us.
Yes.
By the way, there's below each of these colored messages, there's a black print, a long string of characters. You see that?
Yes.
What is that?
That's the source file that I'm ready to just say where the data is coming from.
So if you were to go back to the extraction, that would tell you where to look for this thing?
Yes, so it's really coming out of what we call the DBSQ Lite database, which is the database that we looked at, we find messages like this in.
You see it, then a message a little bit later from Sharif Bay, quoting, "More scared of everything." You see that?
Yes.
And then there's a message a short time later from Jamal Abdullah Bay, owner, talking about the number of people in platoons.
Yes.
13 people.
That's correct.
Now, on the next page, we have two small images. Do you see those?
I do.
What are those images?
They're some diagrams of military maneuvers.
What have I just handed you?
These are the enlarged thumbnail images of those images.
Those come from the extraction?
Yes.
And they're not generated by you, they're part of the message.
That's correct.
We'll offer these as the next exhibit following number for the Telegram chat.
Just might continue projection. But this coming from the Telegram chat exhibit.
But not specific to this particular.
Correct. Nothing beyond what I already established with my previous objection.
Same objections or these being introduced. If you want to stay with maybe 20 minutes. Okay. Just ask what you're going to for us. Good work.
68E, which is 2 pages on the projection. Great. Right, you see exhibit E, you have what appears to be a group of silhouettes grouped in a diagonal fashion.
Yes.
Second page, silhouettes are grouped a little bit differently. They're in diamond shaped groups of 4.
Yes.
go back to the Telegram chat. So both of those are posted by the user Jamal Abdullah. See that?
Yes, that's correct.
At the top, page 12, we have 2 posts with what appears to be the same link. Do you see that?
Yes.
Were to click that link, what would happen? Which page were there? Page 12, the top 2. Thank you.
It would take you to that link that you say argument.com.
What am I handing you now?
This is a printout of that webpage.
And that's just what happens if you click that link that takes you to that page.
That's correct.
After this is the next.
Nothing beyond my continuing objection.
The objection that it will be stated at 68. Yeah.
Putting exhibit 68F on the projector, you see that ports the web page selling 556 M200 blanks, at least a case of them, for just under $600. See that? There's another link. Third message on page 12 of Telegram chat. You see that it's.
I did.
Okay. What have I just handed you?
This where that link takes you to that webpage.
Okay, and again, that's just what's derived from the link.
Yes.
Go off this to the next exhibit.
The continuing objection.
Yeah, we're going to remove the speeds into the 68G. Let's see the exhibit once more.
Sorry. And what does exhibit 68G report?
M23 blank firing adapter or yellow.
It's the website selling an adapter to fire blanks off of.
Yes.
Some kind of weapon. Putting 68G on the projector. Great. Then there's a message below. Second message from the bottom. Jamal Abdullah Bey, owner. You see that it says if any more would like to coordinate to order blanks and blank firing adapters for your training event in July, that would be great. Followed by a message with these, we can practice firing and maneuvering against each other, practice ambushes, assault, fighting positions, etc. See that?
Yes.
All right. Going to the middle of page 13, there's a message. We may need more than 1,000 blanks, though.
Yes.
You see a statement on page 14 of Jamal Abdullah Bey, owner. That depends on how many wars show up to train.
Yes.
Okay. What do you see a little bit lower on page 14, June 13th, 2021, 9:02 a.m.?
The message from Quinn and image attached.
What if I just show you?
This is the full size image of that thumbnail.
Okay, but I'll do this as the next.
Continuing objection again.
That is also true for us. I would just say there's a continued objection to all of the photos. I don't know if your honor wants us to do it each time.
No, it's up to you. I certainly will entertain a continuing objection if you want to lodge it to introduction of materials that are reportedly derived from the extraction. You don't need to repeat the objection each time. You should feel free to wish.
Okay, thank you.
Objections noted and overruled the exhibit. Actually, before this part, could I just, of course. It's 68H.
Put exhibit 68H on the projector. See, that appears to be an individual pointing pistol and some type of other weapon in the direction of the camera.
Yes.
Top of page 15, what do we have?
The message from Sharif Bay, the image attached,
And what's the time and date of that message, if you can make it out?
June 13th, 2021 at 9:04 seconds AM.
What is this?
It's an image of
Time's really the time.
most of the larger full-size version.
And what are some of the items visible in this image?
There's a glove, a sign that says attaches as security in a iPhone with a red case.
What about a clock?
As well as magazines that appear to be inside the magazine pouch.
Robert, this is the next exhibit.
It's the same continuing registration.
Yes.
The objection is noted and overruled. This will be exhibit 68I.
Put exhibit 68I in the projector. All right, you see now at the bottom of page 15, the telegram chat.
Yes.
See the message at 6:21, 2021 at 2:45 from Jamal Abdullah Bay, owner. Can you see that?
Yes.
Could you read that to us?
51 members, and only 5 voted on the poll of who can come to the training events. No one here should ask, why are we impressed? No one should ask, why aren't things changing? No one should complain about the oppression either. No one should ask, where is the militia? I'm looking forward to seeing the true Moors in the flesh. Get ready to sweat.
All right, what do we see at the top of page 16? You see that message at the top?
Yes.
Does that appear to be basically the same packing list for Operation Fountain I had looked at the beginning?
Yes, similar.
You see the request by Jamal Abdullah Bay, owner, asking for pictures of people in militia gear.
Yes.
Second message down.
Yes.
Top of page 17. You see that item?
Yes.
that appear to be a hyperlink to something? Or a web link to something?
Yes.
When this was visited, subsequent to this Telegram chat being recovered, what came up in the web browser upon clicking that link?
Just this, message that said the page could not be found.
Okay. Is there any information at the top of the web browser about the content of the page that once existed there?
Yes.
What does it indicate?
It was a drop down carrot for smoke bombs in a smoke bombs.
Okay. And what is the next message in the Telegram chat on page 17 say from Jamal Abdullah?
Black in or green smoke.
Would offer the printout of the hyperlink.
Might be continuing objection.
It'll be exhibit 68J.
It indicates 404 page not found in 68J, but the smoke bomb portion is at the top. All right. What do we next see on page 17, sort of in the middle left of the page?
Message from individual named Quinn with a image attached.
What have I just handed you?
This would be the full-size version of that image.
And to appear to contain an individual pointing a pistol, sort of off camera.
Yes.
Your Honor, this I would object to on cumulativeness.
I'll hear you.
Look back, where we are with identification. WW's identifications.
First, now that's been marked for ID. If you look at exhibit 68H, person that's in 68H, would you look at WW for identification? First of all, you could describe the position and what the person in WW for ID is doing.
They're pointing at the pistol forward.
How is that person standing and attired?
He has no top on and has a robe or some short patch around his waist, covered the way below.
What do you observe about the two figures depicted in WW for ID and 68H? Whether they're the same or different individuals?
They appear to be the same position.
Yeah. Page 18 at the top, do you see another small photograph or small thumbnail, I should say?
Yes.
What's the thing I just handed you?
That would be the larger full-size version of it.
Comparing that to 68H and comparing. First of all, does it appear to be the same or different individuals?
Same person.
Okay. With respect to the chest area and the garment the person is wearing, can you see more or less detail of that garment in 68H or the photograph I just handed?
Or in the 1%.
And what in particular can you see a little bit better in that?
You can see the lettering of AR-500 clearly in this picture.
Is that lettering white and in the center of the garment?
Yes.
What offer that was nice.
Same objection we just discussed.
Next thing, if you please.
Yes.
I'd like to be heard on the objection. It's 2 minutes till 12:35, for the meeting that's at 1:35.
All right, jury exiting. Who's on the first row, followed by the second row? Please bring them in.
Okay, is the objection cumulativeness, or what is it?
It's the same objection that I just
So that photograph, the additional detail of that's important because there are photographs of Queen Cumberland are walking around with one of the assault weapons or PR style weapons on scene during the standoff, which he's wearing a black ski mask. His vest is visible, and in particular, not just the red flag in the middle, but also that lettering in particular. And it is, I think, relevant evidence to connecting the unmasked Queen Cumberlander, which we have photos of, and people have testified about, with the ski masked armed Queen Cumberlander. Features prominently both in Trooper Casey's body camera, but also in Mr. Latimer's body camera, in other images that the jury is ultimately going to see.
And there are two options. For the same reason that I sustained the objection as to the second photograph in this series, I'm concerned about the incremental probative value, which is in this situation substantial, given the link between the type of vest and Mr. Cumberlander's identification, but also the potential for undue prejudice, which is also substantial given the nature of the photograph. In particular, in this one, Mr. Cumberlander, I'm assuming, I mean, I understand that's an issue of fact to be proved, but I'm just going to, for the sake of the record, say Mr. Cumberlander is wielding a large hunting or military style knife for which there are no charges. So I propose,
and when you the various images of him on camera, you can see that he has a large, I believe it's on his right hip. It's a large white or silver colored, Rambo style or large knife fixed to his hip. So that's the record.
So I don't think, given the significance of the identification issues raised by this photograph, I don't think that just allowing the witness to describe it substantially protects the Commonwealth's interest in proof of Mr. Cumberlander as being victim of video. So I will offer two options to the parties to discuss. One option is a stipulation, which again, obviously require anybody to enter a stipulation, so it would have to be a voluntary stipulation. That in this photograph, Mr. Cumberlander is wearing you could say the subject of the photo, you don't have to say Mr. Cumberlander, but the person in the photo is wearing a vest that has what appears to be the Moroccan flag and an AR-5, the words, the letters AR-500 in parentheses, and is holding a knife, a military hunting style knife with a white
handle. Or if parties don't want to stipulate that effect, I would allow the Commonwealth to introduce a redacted photo that basically has the area of the hands and the vest designation AR-500. So it'll be one of those two things. I'm trying to protect against a verdict driven by seeing what could be viewed as frightening or intimidating photographs, while at the same time preserving the Commonwealth's right to prove its case. So you can either enter a stipulation that makes clear those two facts about this proposed photo, or the Commonwealth will be allowed to introduce a redacted section. Just to be clear, well, no, you know what? I can't. You can't really do it because you need his face as well. So I know that the defense can't preclude the Commonwealth from presenting evidence by stipulating the things precluded, but under these circumstances, I think it's going to be up to the defense. You can either stipulate as to what this picture depicts with specific reference to the labels on the vest and the hunting or military style knife, or I'm going to allow the Commonwealth to introduce it. So,
can I just get clarification on the significance and the relevance of the knife and how that relates to identity?
I gather Mr. Bennett just indicated that because you can see on the video that the person alleged to be Mr. Cumberlander has on his belt a knife with a white handle, hunting or military style knife with a white handle, that he has one in this photograph as well.
The most important detail from the Commonwealth's perspective for this is the face, the top of the vest with the red flag and the specific lettering above that. So if
I think that issue we can.
If I can crop it, and I mean it's going to look strange cropping the way it is, but if I can crop it in that way, and if that's satisfactory to the court, that's what I'll do over.
That's fine. If you can crop it so the weapons aren't. I mean, you may have to include an edge of a weapon. It's not going to be possible, I don't think, to completely eliminate that and sort of the elements you want, but it's the sort of pose with weapons that is troubling to me in terms of 403 balance. All right, so why don't you crop it and then show defense counsel? Hopefully there can be an agreement in lieu of allowing the entire photo. Okay, all right, very well. Anything that we need to very briefly, anything you want to flag for me before we recess?
No, I think Trooper Delaney, we're just going to finish going through the Telegram chat. Beyond that, I don't have very much with him. And, we have McDermott, Delusion, and so on.
Good. And Your Honor, I have my appointment today at 3 in the building.
Right.
And I just wanted to correct.
So what time would you like us to break so that you can be properly prepared for that?
So I have the lunch break to review what I need to review for that. It's scheduled at 3. I mean, we just stopped at 2:55. It's just right upstairs.
Yeah, 2:55 is fine. A full 5 minutes to change gears.
And well, my head's in the game for that. The other thing is, yesterday during one of the Commonwealth's objections to my cross on Heather Sullivan, I made a statement that I did not know what happened to the Bodie report. I was incorrect last night going through my file. I do have it. It just when I prepped that witness, I didn't put that Bodie report in with my folder for that witness. So I apologize, I misspoke, and I correct myself.
Thank you for correcting the record. That's, in my view, all that's important with an error of oversight like that. All that's important is the record is corrected. All right, see you. All rise.
This would be print out of the webpage, this webpage.
And just what I handed you is just a printout. That's what offer this. The R.
Continuing objection, nothing specific about that item.
See, all right, the objection to rule is 68R.
Putting this on the projector, can you see that this item purports to advertise something called a ballistic shield, bulletproof body armor, level 3. Who can other identify? Would you do that?
Yes.
See that link also appears in another message at the top of page 37.
Yes.
You see at the bottom of page 37, there's a question, any more Moors coming?
Yes.
On July 2nd, and what's the response from Colonel Pierre?
I got one other company with me.
Okay. The next message says, where are you? Followed by the response from Colonel Pierre is what?
NY, Brooklyn.
And there's a question at the bottom of the page. Can you get here today? Jamal Bay?
Yes.
Owner. So if you could read these messages on page 39, do you see that they're predicting they'll arrive around 9 p.m. or around 9, I should say?
Last message. Yes.
That last message from Colonel Pierre is posted July 2nd at 12:47 p.m. Is that right?
That's correct.
And it references arriving around 9 p.m. or around 9, I should say.
Yes, that's correct.
You see at the bottom, top of page 41, Colonel Pierre adds somebody to the chat with an identification number.
Yes.
All right. And what is the question from Jamal Bay, owner, at 4:11 p.m. on July 2nd?
Still learning at 5, right? Question.
Do Apple iPhones have a spelling autocorrect feature that applies sometimes for text messaging? Have you ever had a text message autocorrect?
Yes.
Top of page 42, what's the message from Colonel Pierre at 5:02 p.m. on July 2nd? Top of page 43, is there a question from Jamal Bay, owner?
Yes.
What is that?
What is your ETA question mark?
Okay. And who responds?
Individual name by Omar L.
Going back and looking the looking at the top of page 41. You see the identification number for the person that Colonel Pierre added. It ends 94871. See that?
Yes.
Okay. Now look at the response on page 43 from the person using the name Omar L. You see that same ID number as that user's ID number?
I do.
What is the last message in this Telegram chat?
All with it here.
And we didn't talk about every single thumbnail that was in that chat, is that correct?
That's correct.
I would just collectively mark these for identification. I would collectively mark these for identification. And you recognize these to be some of the thumbnails that we did not mark as exhibits?
Yes.
Those will be marked as exhibit, YY for identification.
Now, earlier when we talked, Trooper, about the other phone, I believe that was the phone you described recovering the conduct. We played some videos for the jury. There was one video we had yet played. Do you recall that?
On July 8th.
Let me give you the report. Director of Section will take a bit. I'd like to direct your attention to a video in this report on page 4. You tell us when that was recorded. It was reported by that Apple iPhone.
Yes, this was recorded on July 3rd, 2021 at 12:36 a.m.
I'm playing this video without audio pursuant to the bench conference we have. Can you see the video on the screen? You know, you can stand. I'm going to play it again at half speed. All right, first of all, do you see the object in the center of the screen, the black object?
Yes.
What does that appear to be to you?
The
Pausing for a second, do you see that black object on the left side of the screen? What does that appear to be?
also right.
Do you recognize the interior of that vehicle from your time at Danvers?
Yes.
Which vehicle interior does that appear to be?
Yes, ma'am.
You can have a seat, Trooper.
You are now veterans of this process. We're going to interrupt the testimony Trooper Delaney and take another witness out of order. As I mentioned to you before, obviously you can't draw any emphasis for against either side because there's no evidence to be drawn other than the court in general is juggling a number of schedules. So with that, we will suspend That is you. You're excused, but please stay close. I have two exhibits up here. You can leave the exhibits up there, or, well, yeah, you can leave them on the stands.
Ron, I'm gonna get the next witness, if that's all right.
Yes.
The Commonwealth calls Matthew McCurry. Should have said recall, but
Who's everybody?
Thanks for my games.
it's a different day. I think we should work.
Well, it's not so much day for me because I don't require everybody to speak to be sworn on the every morning, but it's because he's interrupted by other witnesses. So he's here as well.
You solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Back to her. Thank you, Your Honor. You may proceed, Counsel.
Good afternoon, sir.
Good afternoon.
So you could remind the jurors of your full name, and I believe you've already spelled it into the record. Is that correct?
That is correct. That may be true. Matthew McDermott. I'm sure that should stay at least.
Okay. And earlier you testified about some of the bookings you did. Is that correct?
That is correct.
Okay. And one of the individuals you interacted with, I believe you previously identified in court. You recall that?
I do.
Who was that?
Mr. Perez.
Is Mr. Perez with us today?
He is.
Where is he?
On the side of the courtroom, wearing a black long sleeve shirt.
Thank you. And you testified last time you were here a little bit about your time in the booking room with them. During your time with Mr. Perez, were you able to hear his voice?
I was.
While you were doing what you had to do in the booking room, were you also wearing your state police body worn camera report?
Certain times I was wearing it on person, other times it was positioned on the counter, facing the spread, but it was active the entire time.
And remind us approximately how long you were in Mr. Perez's presence during the booking process, during the time that you were able to hear thoughts.
Off the top of my head, I'd say, 10, 15 minutes.
Okay. And was that recorded?
It was.
Okay. And have you also had occasion to listen to the voice of Mr. Perez prior to this?
Yes.
Okay. Let me show you something real quick. I just want to put it in the computer for you. Tell me what the item is that.
The DVD is labeled Perez voice. Example.
And does that contain a
portion or a snippet of audio from your body worn camera during your time with District Resident at the Medford booking room on July 3rd, 2021?
I know that.
To review a set of transcripts before coming here.
Yes, sir.
And was there a particular voice that you recognized in the transcripts based on your time in the Medford Barracks booking room?
Yes, sir.
And which voice was it that you recognized?
On the difference.
And do you see portions in the transcript where it lists a person speaking as a disputed male speaker? You see that?
Yes, sir.
Based on your prior review of the transcripts, your recordings, and your familiarity, you identify that voice previously.
I did, sir.
And to your knowledge, based on your familiarity, whose voice is that?
Based on the footage that I watched, it was on the difference.
Mark the transcript for identification.
Transcripts will be marked Exhibit ZZ for identification.
Your Honor, the audio on this is extremely short. I would ask that the witness be able to just take the laptop into the hallway and listen to it. Come back in and tell us if you can authenticate it. Any objection then?
No, Your Honor.
You may do so. All right. Perfect. Come with me.
First, it's certainly be a good time to stand and stretch now. I don't want to take a recess because I don't think this is going to take very long. But if anybody would like to stretch or relax a little, it's already relaxed. But, please feel free to stand and stretch if you want.
Very welcome. Very welcome back. You had a chance to review the disc that I handed you a few minutes ago.
I did, sir.
Okay. What did you recognize it to be?
That was a recording of Mr. President's voice specifically from the booking.
Okay. And okay, and you recognize that your body worn camera recordings?
Yes, sir.
I would offer this as next objection.
You object? Yes. Based on the previous objection.
No, this is it.
Okay. It will be marked as
7-1.
The record, are you going to now play Exhibit 127?
Yes, I'm just queuing up the software to do so.
Very well.
Yes.
Come on.
I'm going to play Exhibit 127. Yes.
Someone walks and say, meditate conservatives, hopefully more Senate and stand with those big peace. 200 years from now, they will never know their forefathers and forefathers were.
Whose voice is that?
That's Mr. President.
The transcript, which I marked for identification. We talked about recognizing the voice of Mr. Perez for the area. It's a disputed male speaker. Have you seen that?
Yes,
These transcripts pertain to a series of videos that you reviewed prior to today.
yes, sir.
There's a few instances in these transcripts where it attributes statements to Mr. Perez directly, meaning he's named in the transcript. In some places, and in other places, it says disputed male voice. Do you see that?
Yes,
Okay. In the areas where it attributes statements to Stephen Perez, whose voice do you recognize in the speech?
Mr. President.
I have nothing further for him. Trooper McDermott.
No cross from Mr. Abdullah.
No questions.
Trooper McDermott, I'm pretty sure that really does conclude your testimony for good. Thank you very much.
Thank you.
So we're going to resume with your testimony of counsel. The work for all counsel to continue to resume the testimony, albeit briefly, of Trooper Delaney.
I think I only have a couple minutes left. No,
sounds like it works perfectly. No problem.
Trooper Delaney, with respect to cell phone messaging applications, have you heard the term end-to-end encryption?
Yes,
What is it, or what is your understanding of?
I'm not an expert on it, but when our messages are, well,
Objection.
Sustained, perhaps you can lay more of a foundation.
Okay. Have you encountered devices that have Telegram installed on them during your time as a state trooper?
yes,
In particular, have you encountered devices that have that application installed because you're going to examine?
yes,
Are you familiar with any of the features of the Telegram application?
there's some.
And what are the ones that you're?
I'm familiar with it as a messaging app that doesn't store data, user data in messages, the company themselves. They don't keep things on the server. Everything that's on their servers is encrypted, so you can't. Company themselves doesn't have access to that data.
So it's essentially only available to the end user.
Yes.
That's all I have for the ruling. Mr. Johnson, thank you.
Good afternoon, Trooper. Good afternoon. So you testified that on July 3rd, you participated in a search of the Ford Transit van and the Honda Ridgeline at the state for the same place.
That's correct.
And later that summer, you went back and you participated in another search of those two things. Is that correct?
That's correct.
Now, I want to go over who was present for that initial search on July 3rd. So that search started at around 10:30 at night. Is that correct?
That's correct.
Is it fair to say that they're members of the Middlesex State Police Detectives Unit who were there?
Yes.
And they were members of the Crime Scene Services section there, correct?
That's correct.
Now, those are uniformed, well, maybe not always uniformed, but those are sworn members of the Massachusetts State Police, is that correct?
Yes, that's correct.
And they were also members of the ballistics section from the State Police Crime Lab, correct?
Yes.
Was there anybody from the Crime Scene Response Unit there?
Crime Scene Services.
Correct. So, were there any civilian members of the state police or the state police crime lab present for that?
I'm not very recall.
And just to be clear, the crime scene response unit is not necessarily part of the crime scene services section.
That's correct.
One is for sworn members of the police, and the other one is civilian.
That's correct.
I'm going to put Exhibit 126 back up on the screen for you. Do you recall that? Can you see the screen? There we go. Trooper, can you see the screen? Okay.
Yeah.
You may. Okay. This is one. Okay. Yeah, I don't need the point. Okay. Okay. Thank you, Grant. So Trooper, this is the last video that you testified to on direct examination. Is that correct? From the Telegram chat.
That's correct.
All right, so I'm going to go through this video without the volume on. All right, so in there, that's the first alleged firearm that you testified to in this car, correct?
Yes.
I'm going to press play again. All right, what do you see in the front passenger seat?
It's the individual person seated.
All right, so just one person that, so far as you can tell? Okay. I'm going to press play again. All right, I'm stopping it. What do you see any people there in the video?
Yes.
All right, and that's about the 8-second mark? Do you see any alleged firearms in that portion of the video?
I do.
And do you see that somebody is holding that alleged firearm?
Yes.
And press play again. All right, and right before that clip ended, did you see the right arm of the purported driver? So right there at the, I'm gonna pause it right before the end, and then at the very end, I want you to let me know if you see somebody's arm from the driver. Did you see an arm?
A hand or an arm or something.
All right, but fair to say somebody is driving that car.
Oh, yes.
Okay, so including the camera holder, there's 4 people total in that car.
I see 4 people.
What you see is 4 people.
Yes.
All right, you can resume the witness stand. All right, so you see one rifle in the hands of whoever's holding the phone, and then another rifle in the hands of the passenger seated to the left of the whoever's operating the phone, correct?
Yes.
So you testified on direct examination that you responded to I-95 northbound Wakefield around 6:30 a.m. Is that correct?
That's correct.
What time did you leave that scene?
I don't recall the exact time. Sometime right after the arrest and transport to the hospital.
And so you were present for the arrest of whoever was arrested in this case?
I was on the scene. I was in the command post, so I couldn't visually see anything happening.
And so you're not personally present for the arrests of the suspects in this case?
That's correct.
Lance, you get just while you're in the transition, speak to everyone on their consent. What I hope would be a pleasant surprise. The reason it's a surprise is entirely my fault, because I knew that this issue was out there. And for a variety of reasons I won't bore you with, didn't think to tell you this in advance. But we are going to recess a little early today, that is now. And as I said, I knew that that was a possibility, but I wasn't sure how it would play out, so I didn't advise you of it. But I hope it's a pleasant surprise. We are going to ask you to be back here tomorrow at 10 once the other work we need to go outside your presence. So in a moment, you'll be free to go for the day and see you tomorrow morning. Remember to discuss the evidence or anything about this case with anyone, with each other, that is arbitrarily part of the deliberating jury, even then only for formally the deliberation. Please, as you know, discussion includes using a cell phone, tablet, or other electronic device to text, chat, email, tweet, blog, or post anything about the case, social media, other electronic media, or anything else. Any kind of post like that have to wait for your jury services, included in discharge. Please continue to have no communication with the lawyers, parties, or witnesses in the case. I expect they will do the same with respect to you. Please continue not to read, watch, or listen to any coverage about this case that you might encounter in traditional media, social media, or anywhere else. Recall my 2 instructions: if you are exposed to any coverage, first, do your best to minimize the information you take in. We've talked about how to do that, and do not mention it to your fellow jurors in any way or even refer to it. Instead, wait till your court officers speak to your court officer, try to let them know what it is you've been exposed to. Finally, please don't do any research or investigation about this case, online or otherwise, or allow anyone else to do so for you. So with that, I hope as well, the weather is not as nice as it was the other day, but hopefully you can enjoy the rest of your afternoon. See you tomorrow morning.
All right, jury incident. We start with first roll, followed by second roll.
Maine in session, when we recess, what I'm gonna do, I'll leave it up to the court officers whether to take Mr. Lucia L down back to lockup, or whether to keep him here in the interim. And we'll wait for Mr. Thompson. As soon as you're free from the interview, for the meeting, if you would, just come straight back to the courtroom, and we'll follow Mr. Wall's suggestion and try to do as much work on the instructions as I can before. Thank you.
Your Honor, the chat, a copy of the exhibit that the jurors have, I assume just like stays with their notebook. Like they all still have.
Yes, they don't take materials home. Anything that they're given stays with their notebook. Probably should have thought to collect them, but we can do that first thing tomorrow.
That's fine, thank you.
And I'll be out as soon as Mr. Thompson today.
What? All right.
Thank you.
And back on the record, we had left off. I forget exactly where you were also that indicated he was going to ask for instruction knowledge that the minor alleged to have access to the firearm wasn't back in minor. I don't know if that's where we left off or just a straight.
I think he wanted, because it was not in his comments, I think he wanted to report that I actually think I have a very simple response to that, which is there is a case right on point about the language that needs to be on the statute, when you actually require that, and when you don't.
What's the name of the case?
Pull it out of my notebook. Second.
Well, as you're looking for it, it occurs to me that the statute has to have some knowledge of firearms because the purpose, right, is to put someone on notice that they store a gun in a place where children have access without trespassing. And the without trespassing part is otherwise, presumably children have access to everywhere, right? And if they, yeah, I have no minor children living with me, but I mean, I also don't have guns, but if I did, the neighbor's children could have access to my house by trespassing, right? They could break in, so it would punish everyone. That can't be right. It has to, obviously it's a place that minors have access to without trespassing.
Well, right, access to the part is clear.
But I have to know that minors have access to it without trespassing. Otherwise, it's nonsensical. I mean, you can't tell somebody don't improperly store a gun in a place that minors have access to, even if you don't know they have access to.
Well,
it doesn't make any sense.
So I follow that logic. I was just focusing on, you don't need to know that the person's a minor. And the case on point.
Of course you do though, because if you don't, like if there's a person in my house and I don't know, you're saying you basically take the risk that anybody can be a minor if in doubt, ask or something like that.
Correct, in the case law, so Commonwealth versus Montcalm, it's a 2000 Mass Appellate Court decision, 50 Mass Appellate Court. Okay, sorry.
I need to put it into a search line. My computer is decided now is a good time to stop working. Yeah. Your position is that the statute puts the burden on one who owns a firearm owns a firearm to figure out whether anybody who has access to it may be a minor.
Right, so we have to prove on that point that a minor can have access, right? That it's a location where a minor can have access. In that case, it's not a location, but
I mean, I'm sorry, it's 15 Mass out of court.
It's 50 Mass Appellate Court 85. And what it does an excellent job of explaining and then I'll let the court read it, is that it delineates the various statutes with age requirement, and it says, as a general principle, proof of knowledge of age by the defendant is not required. That's the starting point of the statute. And it was interpreting exploitation of a minor to distribute drugs doesn't require knowledge of age, but it goes through all the statutes. What it makes very clear is that unless the statutory language says at the beginning that you need to have knowledge of the age, so child pornography possession, there's one or two other offenses.
Can you just repeat the same 15 mass appeals?
Oh, 50 mass appellate court.
That's why.
So what it very clearly says is that where the legislature does not say specifically that you have to have knowledge in the actual statute, so it has to say with knowledge that someone is under the age of 18 or under the age of 14, whatever that statute says. The way that the statute should always be interpreted otherwise is that it does not require a knowledge requirement as to the age of the minor or child. And I think the case does a great job of explaining a summary of all the statutes that they have interpreted in the past and explain that statutory construction. So I think it's black letter law that unless the statute says otherwise, you don't have to prove knowledge base.
I'm reading the case quickly, Mr. Thompson, but my quick reading, and I will read it more carefully when it's not on your time, is that counsel's right. As a black letter law, if the legislature has to say with knowledge that a person is a minor or the person under 18, and I can understand why that would be. Basically, if you're keeping guns in your house, you have an obligation to find out whether the people who have access to it are minors or not. And that puts the onus on the gun owner to be careful, which is sensible. So maybe you should give a read to Montalvo. I'll hear you if you think that somehow it's not on point, but like a quick sort of skim read of it is that it says what Mr. Rawl says it says. So, assuming that I continue to think that, I won't give a knowledge instruction. All right, where are we next?
So I believe that the Commonwealth left on page 12, and there actually aren't, I'll say this as famous stuff, there aren't a lot of comments left in the Commonwealth that haven't already been addressed. Just sort of the consistent comments are that obviously there'd be a reference to joint venture at the beginning of every charge, and then the verdict slips will all.
Although every charge accepts false name of police and body. Right.
And as we go through the counts again, because we specified in the indictments the types of firearms, the verdict slips will have to do that. So I'm going to move past all the way to page 16. And I only flag that from the Commonwealth's perspective, for the verdict slip, the possession of ammunition charge. Logistically, there's so much ammunition, and I think this is an example where an instruction should just be given. You have to collectively find at least one piece of ammunition to spot, because I don't think there's any other way to do it.
Counsel?
I think that's fine.
Oh, no objection to that.
Okay, I'll make that. I'll add that.
On page 17, I just want to flag, I don't think it's an issue per se, but technically, carrying loaded is a misdemeanor, but it's also sentencing enhancement, so I don't think they should be instructed on it, but I don't think there's any logical way in which a jury can come back that carrying loaded and not come back on 10A. I think that they shouldn't be instructed that that's not a felony. Right.
Your Honor, there is the, if I understood that they cannot convict, if they convict on a 10N, they must convict on a 10A?
It's not a standalone crime. So if they come back not guilty on all 10As,
right,
even if they came back guilty on a 10N, it's not a standalone crime.
That conviction would have to be vacated.
Okay, I misunderstood what he was saying.
Yeah, it is true that if they don't convict on unlawful possession of a firearm or unlawful possession of a shotgun, but they do somehow, which is hard to imagine how, but if they do, if they were trying to break just on carrying a loaded firearm, then the conviction can't stand because it's only a sentencing enhancement for the unlawful possession.
So, Luis will come up to the last comment, and I'm thinking.
Before you do that.
Oh, sorry.
Oh, are you about to talk about your standing objection to?
So I wrote it that way because at first I really didn't know how to address this, but I do have a suggestion from the court from Kamal's perspective.
Yeah.
The Kamal understands sort of the position here where the court has said that it will call people by their preferred name. Kamal obviously didn't object to that. But I think in this section, the Kamal would ask for the court to give a instruction that you basically shouldn't infer anything from the fact that I called Mr. Abdullah Bey by what the name is that he prefers. I have no opinion about whether or not that's his legal name or whether or not he gave false information relative to this element. Something to that effect, because I think the result of the court constantly using the name that the Commonwealth is alleging is the false information that was given at booking. I think it needs to be addressed in some way. And I'm not going to suggest the court just change the section, same as the ladder. That was going to be my original suggestion. I don't think that makes any sense.
No.
I think instead I would ask the court if on this particular, as I told you before, anything I say is not evidence.
I think that's
Please
fair.
don't
I think
consider.
that's a good idea, Mr. Thompson, because candidly, it hadn't occurred to me that my choice of referring to Mr. Abdullah Bey by the name he prefers might be perceived as undermining one of the charges. It wasn't intent. That wasn't my purpose, obviously, in doing it, but it hadn't occurred to me. I think it's fair to say, essentially, Mr. Rawls said that, as I explained to you before, nothing that you're not to take anything that I do in this case as expressing an opinion that on any of the issues in the case. I'm required to have no opinion and therefore do not express one. That I've chosen to call Mr. Abdullah Bey by the name he prefers has no bearing on the issue of whether or not he furnished a false name of a police officer in connection with the crimes.
So a couple of points said, so not to constrain my closing, but I wasn't going to argue to the jury that just because the judge calls.
No, of course, I appreciate you not doing that, and I would frankly that would have been a problem had you done it. But I think what Mr. Rawl is getting at is, even if you don't make that argument, the jury may interpret me using Mr. Abdullah Bey's name in that way. Mr. Abdullah Bey is an indication that I believe it's a valid name for him to use, which I do believe it's a valid name for him to use now, but I have, by law, no role in deciding whether it was a valid name for him to use at the time of his arrest. So now that the dust is settled, I have no problem calling Mr. Abdullah Bey, but that isn't a reflection that I have determined that he acted lawfully in giving that name to arrest. I have no opinion as to whether he acted lawfully in giving that name to arrest. That's solely the province of the jury to decide.
So your Honor would give
don't take anything I do or say as expressing any opinion as to how you should resolve the issue of the case.
Given that I interpret that as what the law should be, and it doesn't constrain what I was going to argue anyways in closing about that. I don't have an issue with that.
I will give that instruction. It's fair. All right. As far as the defendants not testifying instructions, I'm going to leave them in there as is, unless one or both defendants testify, in which case I will obviously move them.
Just to make a clear record, Mr. Abdullah Bey specifically does want that instruction if he does not testify.
Got it.
We have the same position.
Okay, so they'll be in there. If as to either defendant who doesn't testify, it'll be in there. If either defendant or both defendants testify, it obviously won't be in there.
both defendants testify, and if it's only one defendant doesn't testify, I'll specify you made a notice that Mr. Abdullah didn't testify, or you made a notice that Mr. Luciel didn't testify. By the way, the instructions, just to point out to Mr. Rawl, I've written the instructions as Mr. Latimer Abdullah Bay and Mr. Perez Luciel. My reason for writing the instructions that way is what you highlighted, that I don't want to express it. I still will give the instruction you requested because I refer to them by their preferred names. But it just occurred to me that the entire instructions are written using both.
Well, that's why I didn't propose just changing that section.
Right. And Mr. Raw, you know that we should give the opinion evidence instruction because we've got experts, so I intend to do that. But I'm not going to give a humane practice rule instruction because neither party is going to be voluntary statements. So that goes out.
So I did raise it in the email I sent, but I think the only glaring other is co-conspirator statements that I think should be put in.
If you have a version of the instruction you like, email it to me right away. I think there's a model instruction.
I think there is, and that's usually what I first do.
And I'm trying to think where it should go.
Usually, I think the MCLE model, it's part of the aiding and abetting in any joint venture charge thing. I do have one that I can send the court that I've used recently, but I think in the last trial I did, I think the judge split it so it was in the evidentiary section, not the charge.
It belongs in the evidentiary section. And I think I'll put it right after credibility before opinions.
Yes, that's fine. That seems to be where most of the evidentiary sections go.
Right, so we need one on. Probably, given how the case seems to be going in, it's going to replace subsection 1, prior and consistent statements by a witness. That's where that is now.
And I know the court is going to give an instruction, but I think it may make sense.
And I'm going to call it joint venturers, not co-conspirators. Okay, because we haven't used the language of conspiracy anywhere, so statement joint venturers.
One final piece I was going to suggest was where the defendant's, the voluntariness is going to be removed. It may make sense to just give the same instruction about the transcripts in the actual final charge. Because I saw that wasn't in there, and I think that given the disputes about the transcript, and given the instructions the court's going to give when the transcripts are entered for the body camera footage tomorrow, it would make sense to put it in the final charges, the description of what you can and can't consider in that.
Right, let me first ask, Bracelet Cone, have we now addressed all of your proposed revisions?
Yes, sir.
And Mr. Thompson, we've addressed the question of the knowledge requirement about whether somebody's a minor, but I haven't gone back since we submitted yours and I reviewed them to see what else is in yours.
There's nothing else in mine. Once I finish my assigned attorney basic funds, mine are basically incorporated in hers. So to the extent she raised the joint ventures issues, as I said at the beginning of the charge conference this morning, I joined those and lodged my objections to what you didn't give her that I would have asked for from Mr. Bilbay.
All right, what I plan to do, what I will do is send you out a working draft before I leave for today. I don't know exactly when that will be, and it won't be, I don't think, conceptually, but, and then what I'm gonna ask the parties to do is, I can ask it this way, but review it this evening and submit any proposed new revisions, just start doing work from the document party, work from the draft by 8:30 tomorrow morning. Email is fine. Now let's talk about the logistics here. We have the jury coming back at 10 because we anticipate finishing the instructions before then. The Commonwealth, when ballpark figure, when does the Commonwealth anticipate resting tomorrow?
Well, we're still on cross of Delaney, right?
Because we're in the middle, well, early in my class of Delaney.
Yeah. So, as you know, these redirects, there's Trooper DeLucia, who was very short, and then Trooper Sullivan, who's probably, including playing the videos and going through with the transcripts, maybe not. I don't think it's hard for me to forecast without an idea of how long across the Delaney will be, how involved that is. But those are the only witnesses left.
So, plausibly by lunchtime.
Possible.
And then I think counsel has said that you don't anticipate calling witnesses other than defendants. I think I have that right. Right.
That's correct.
Yes.
So playing this out, if the defendants testify, it will likely be around lunchtime, maybe just the beginning of the afternoon. And if that happens, then we would, and then the defense rests absent rebuttal by the Commonwealth, we would sort of finish at that point and do closings and charge Thursday morning. If the defendants don't testify, I guess the reason I'm thinking this through is if the Commonwealth's case goes in relatively quickly, and well, here's what I think. You can tell me if you think this makes sense. If the defendants testify, that'll be the last thing we do tomorrow, and then Thursday morning we do arguments or charge arguments and charge because I split my charges. If the defendants don't testify, assuming the Commonwealth's case is finished by lunchtime or thereabouts, I think it then makes sense for me to do the first part of my charging on the law after lunch or at lunch or after lunch, and then discharge the jury, come back Thursday morning and just do closing arguments. I say that because the first part of my charge is going to take a little while. We haven't discussed how long each of you need for closing, but there are 3 closings. I don't want to split the closings with, for example, defense doing their closings on one day and the Commonwealth having to wait for the next morning. So no matter how long you're taking it, I can see that, particularly from the Commonwealth point of view, but arguably from the defense point of view, if not equally, then substantially, that these are fairly involved closing arguments. There's a lot of detail. And I just don't see getting the first half of my charge and 3 closing arguments done after the Commonwealth's case, even if the defendants don't done. So I think the thing to plan on is what's up in the air is whether I do the first part of my charge tomorrow, lunchtime or after, or not. That's really the only issue left. Do people agree with that?
I think that makes sense. That's it.
Yeah, I agree.
All right, so that from your point of view, I gather you don't mind knowing that you don't have to open until Thursday. And I think it makes sense. We may have a short day for the jury. If it's the Commonwealth's case that goes fairly quickly, and then my charge on the law and we discharge them, so be it. But all right, how long do you each need for a close?
6 days. I'm just kidding.
So I'm probably gonna go past the 30 minutes.
Well, 30 minutes is in the rule. I don't think that most cases in Superior will actually to that. There are many cases in Superior Court that require more than 30 minutes for closing. So that's a very loose guideline that I don't put much stock in. I need to know how much you actually think.
I mean, my best guess at this point is about half an hour.
I'm probably not gonna be much past half an hour.
Okay.
I'm gonna try to keep it on me.
How long?
I'm gonna try to keep it to 45 minutes, Judge. I have 2 different closings to rebut, or to talk about, I should say, plus whatever I want to talk about anyway.
Why don't we say this? We'll call it 45 minutes as a guideline. Candidly, unless if you're at the 45-minute mark, unless you are simply repeating arguments or making arguments that aren't topical, I'm not going to say anything. If you reach the hour, that's the point at which I might say council time to start thinking about, wrapping it up. And it would have to be a while past that before I would actually stop talking now. So we'll say 45 minutes, but it is an extraordinarily loose 45 minutes designed to make sure that nobody goes, for example, 90 minutes. Right? Okay. And that further made it included. You shouldn't take it over until 30. Anything else we should discuss before we recess for the day?
I just wanted to apologize to Attorney Thompson. There was one of his objections that at the end of the day, and I was extraordinarily frustrated with, and I let out a noise that I know he heard and turned away from the jury. I don't think they heard, but it was insulting to him, and I shouldn't have done it. And I apologized to him in the hallway, but I wanted to apologize to him before it.
Well, that's I think that's very professional of you. I did notice it. It struck me candidly as out of character, given how professionally you conducted yourself. But once again, as I think I referred to earlier, it is of much less significance to me that it happened than that you did the admirable thing and apologize for it. So matters closed in my mind, and I appreciate your doing that. All right, in that case, we will call it a day. See everybody back here by 9. Firm goal of not bringing the jury out by 10. Thank you.
All right.
Let's go.